Welcome to today's session. Today we will talk about Chapter 5, Negotiation Models, Strategies, and Techniques or Tactics. And today we're going to talk about negotiation models, strategies, and techniques that you can use to effectively negotiate with the other party, whether you are a union representative or whether you're a management representative team. The goal is for you to have certain skills that are needed so you can negotiate effectively on behalf of those individuals and employees and workers or managers that you're representing. This is a big chapter, a very comprehensive chapter that talks about the skills that you need, whether you're working on the union side or the management side, to negotiate with the other party as honestly, as effectively, and obviously as ethically as possible. So these skills can be very helpful whether you're in the private sector or the public sector, or even if you are negotiating in regards to politics between two or more parties that are trying to settle certain differences. So some of these negotiation skills and bargaining agreement skills can be used in politics as well. Over the last 2 decades in Afghanistan, you've witnessed oftentimes where 2 or more parties have had to settle their political differences in order to create a unity government. So these skills should be very helpful and useful in those regards as well. Before you can start negotiations, we have to make sure that the foundation of negotiation is correct and both sides have a strong foundation to be honest and also to have the skills for the right attitude toward win-win thinking for both parties. So ethics is one of those foundational principles that must exist in order for both parties, the 2 parties or more, to build trust and also to move forward toward win-win thinking for all sides involved. So what is ethics? Ethics is the principles of conduct which govern a person or a group's overall behavior in a day-to-day decision making or in interpersonal situations, or when it comes to the 2 sides trying to negotiate and bargain with each other. So ethics are standards that you use to decide what your conduct should be. And when it comes to ethics, keep in mind that there are appropriate tactics, there are marginal tactics, and also there are inappropriate tactics. So if you're looking in your textbook for ethical and unethical bargaining techniques, I think this graph gives you a good idea of basically whether to be on this side or whether to be on this side. For example, when it comes to appropriate techniques, these techniques would gain information about the opponent by asking associates and contacts. Make an unrealistically high opening demand might be appropriate in some cases because you are making the first offer in terms of negotiation. Hiding your real bottom line is often a practice that's used in negotiations in order not to give the other party an advantage. And then giving false impression that you aren't in a hurry to pressure your opponent. That's another negotiation technique, even though you are in a hurry, but we don't want the other side to know that we are in a hurry. So these are appropriate techniques that could be considered ethical, because you're not presenting necessarily false information, but you're just trying to make sure that the other side does not pressure you because of your situational variables. On the other side, we have the inappropriate techniques that could be unethical in some cases. So misrepresenting factual information to support your own position might be inappropriate and sometimes unethical. Falsely threatening your opponent is definitely inappropriate and obviously could land you in jail. Promising good things with no ability to deliver, again, this not only is not right, but it also could land you in jail. But furthermore, it can also decrease the level of trust between you and the other party. In bypassing opponent's negotiator to undermine opponent's confidence in him or her. Finally, gaining confidential information from your opponent, again, is considered inappropriate technique to use during bargaining or negotiations. For a negotiation model, here are some general things to keep in mind. So for the opening statement, Describe the big picture of the negotiation situation. The past relationship between the parties, current issues to be presented during the negotiation, as well as the major external factors in the concerns of both parties need to be discussed. Suggest ground rules that will facilitate the process. Start with the 5 W's. Who speaks for each party? Where will negotiations take place? When will sessions begin and for how long? What form of agreement is acceptable? How will formal proposals be made and agreed upon? So these are the 5 W questions that you can start off with regards to suggesting certain ground rules on your side and also on the other side. List the key issues which must be resolved to reach a settlement and ask for a list of the other party's key issues. These issues are often economic in nature and they could involve wages, benefits, or cost. However, the other non-economic issues such as seniority, grievance handling, or subcontracting might also be a key issue in a particular negotiation. Next, have the first negotiation session. This is where you would be presenting the proposals. So first of all, ask the other party to present their proposal first, perhaps. So as they're presenting their proposal, listen intently to determine its true, genuine interest on issues which underlie its opening positions on those issues. Second, utilize active listening skills. As the other party presents its case, acknowledge what he or she is saying with reflective statements like, I hear you saying this, or my understanding is that you prefer things to turn out this way or to go this way. And also ask open-ended questions such as, why are we needing to talk about this issue or that issue? So when you ask an open-ended questions and you're using reflective statements, you're trying to better understand the other party's interest. That's your genuine intention and interest. And third, whenever it's possible, identify common interest between your side and the other sides, which might be easily resolved. And those would be the first items that you would focus on because you both have that in common. Third would be to negotiate minor issues first. Identify the minor issues that should be easier to resolve and try to build momentum from there on. Suggest logical trade-offs or packages of issues that provide some gains for your side and the other side. Include throwaways in your list of issues to build momentum and provide you leverage to make trade-offs for issues that are going to be of greater value. Infrequently mention that both sides need to satisfy some interest and realize mutual gains to reach an agreement. So ask the other party to brainstorm new options together. Next, negotiate key issues. With key issues of economic value such as wages or healthcare, frame each proposal with persuasive arguments and use relative norms when appropriate. When a distributive process is utilized, make the first offer to anchor the negotiation, or you can let the other party make the first offer to enable you to respond with an offer to create a favorable settlement range. Once the settlement range for an issue is established, make small incremental concessions to lead to your desired settlement value. And only make large concessions if matched by the other party. Try to never counter your own proposal. And when it comes to responding to proposals, always take time to evaluate a proposal, because rejecting immediately may signify to the other side a lack of sincerity on your part. When rejecting a proposal, explain why it does not meet your interest or your side's interest. If time is available, ask to suspend the negotiation to research data or information which may support your interest or question the other party's interest or clarify a fact that is in dispute between the two sides. Caucus often to rethink your interest, evaluate the other party's proposal, or to simply regroup your team. Never ever allow team members to express conflicting views at the table. In other words, when the other side is present, be one voice. Each party does not need to speak on behalf of his or her own ideas, but each party needs to speak with one voice on what you all agreed upon prior to the session. Avoid possible impasse by suggesting the issues which appear to defy resolution to be placed on the back burner until the end of the negotiation. So in this case, the back burner might be items that you basically list on a flip chart, and you'll talk about those later on, as opposed to simply halting everything at the present moment. At the closing stage, to facilitate the closing, in the ground rules provide the issues that are agreed to during negotiations be signed off and dated and removed from the table for further discussions. A written, signed, and dated agreement or contract is standard in collective bargaining negotiations. One party can offer to prepare the first draft of all the signed off and agreed provisions, and the other party then proofreads the draft. Expect many of the issues to be settled at the end. In the last 10% of negotiations, that is a somewhat normal process. When it appears that a deal is very near or very close, you can expect that the other party will try to nickel and dime you to close the deal. So always be prepared to simply walk away. So be prepared to walk away rather than to make any major last-minute concessions just to achieve the over factor, which is your desire to get the process over with. After all the issues are agreed upon, the union will offer it to its membership. When it comes to bargaining strategies, know that collective bargaining generally involves one of two strategic approaches: distributive or integrative. So distributive or integrative. In considering which approach might be best for a given collective bargaining situation, first, a negotiator should review the information, the timing, and the amount of power that your side and their side has. Think about the specific issues that need to be negotiated between the two sides. Think about the people who are involved. Do they have the right skills? Do they have the right attitude? Do they have the right level of power and influence? And also think about the general context of the negotiations. What would be the most favorable for your side as well as for both sides to have win-win outcomes? Distributive bargaining is a negotiation method that is described as a win-lose situation, in which resources are viewed as fixed and somewhat limited, and each side wants to maximize their own share. Distributive bargaining can be best explained by 5 key elements: the target point, the resisting point, the initial offer, the settlement range, and the settlement point. 3 key starting values are the desired outcome that you want, the bottom line that you can agree with, and the opening offer. So negotiators make opening offers with one of 3 types of anchors: the facts, the extreme offer, and precedent. So this chart gives you a good idea of basically what the management side needs to think about and what the union or the labor side needs to think about. So if you're in the management team, think about your initial offer, your target point, your resisting point, and this is the area you would settle. In other words, given certain concessions, you'll be happy in this range. So make sure you're clear about this before you go into negotiation. So this is what we call the pre-planning stage. If you're in the union or labor side, again, know the resisting point, know the target point, and know the initial offer that you will make if you're given the opportunity to go first. So keep in mind, there are both extreme sides and what you can be happy with given certain concessions on each side. Typical negotiation norms include relational norms, fairness norm, reciprocity, good faith bargaining for all sides. So let's talk about some of these norms. Relational basically means your desire to maintain a positive long-term relationship, especially important to most labor management relationships. And in terms of fairness, you can think about equality, equity, need, and status quo. In equality, you evenly split the difference between the opening offers. In equity, you split the difference between the offers based on the proportional inputs from both sides. When it comes to need, you split the difference between offers based on proportional needs of each of the parties. In regarding status quo, you leave the current situation unchanged. Many contract provisions are not changed during the negotiation of a new agreement because the impetus to keep current language, especially if it is working, is a good thing. When it comes to reciprocity, you respond to a counteroffer or action with one of equal value. For example, the union has increased its health insurance copay offer by, let's say, $5. Therefore, management responds with a $5 decrease in the proposed copay. Good faith bargaining basically means that negotiators will, 1, honor and not retract an offer, 2, meet and discuss the issues, 3, make sincere proposals, and 4, provide copies of any data or information used during negotiations and share resources of information. So what do we mean by framing your position? It simply means presenting an issue to the other side in a negotiation in any way that is convincing and causes the other side to see the proposal in a different light. Hopefully in a proper light that is beneficial to your side and to the other side. There are 4 types of frames that are usually applied to grievance settlement. So reframing, focus frame, contrast frame, in negative frame. So the goal of the union's approach to framing the issue and also in response to management's initial positions, you can look at this table in your textbook to look at the details of each of them. For example, when it comes to reframing, the goal of the union's approach to framing the issue would be to change management's context from a cost decision to an employee morale decision. And when it comes to focusing the frame, change management's context from a cost decision by focusing on the uniqueness of the grievance. And when it comes to contrasting the frame, change the management's context from a single payment to a much smaller monthly stipend. And finally, when it comes to negative frame, change management's context from winning to simply avoiding a loss. And you also study, obviously, the management's response view. You can use framing questions like asking why not, what if, and ask for advice. What would happen if we do this? What would happen if we do that? In integrative bargaining, both sides seek ways to integrate the interests of both sides into mutually agreeable options. So here, both sides are trying to aim for a win-win outcome for your side, but also for the other side, because you want the relationship to be sustainable. Keep in mind, whenever one party loses, chances are very good that the relationship will be discontinued or they will come to an impasse, meaning they will not accept it. If they accept today, they will quit the relationship tomorrow, next week, next month, or next year, because what they've agreed upon is not sustainable. So integrative bargaining is a good option in most negotiation situations. So the integrative negotiator generally strives to achieve two goals: to create as much value as possible for both sides and to claim as much value as possible for their own interests. There are a number of common differences between distributive and integrative bargaining techniques. So when it comes to number of issues in distributive bargaining, usually you consider one issue at a time, but on integrative bargaining, several issues are negotiated simultaneously. In distributive bargaining, we have win-lose. On the other hand, in integrative bargaining, we have win-win. When it comes to relationship of the parties, for distributive, you have a one-time relationship, but on the integrative bargaining, you have a continuing long-term and hopefully sustainable relationship. In terms of your interest, in distributive bargaining, we keep our interests hidden, but in integrative bargaining, it is shared with the other parties so they understand where we're coming from, and obviously so they can think win-win as well. When it comes to possible options, in distributive bargaining, you express your position for each issue. But in integrative bargaining, there are many options, so you create new options for maximum mutual gain for both sides. And finally, when it comes to information factor, in distributive bargaining, usually we keep it hidden. But in integrative bargaining, you share with the other party, explain why your position is the way it is, and explain your interest. Principled negotiations require that you emphasize positions and separate people from the issues. Focus on objective criteria and develop mutual gain options. Let us look at the positions of union versus management when it comes to your interest. With regards to position, management would like to change work assignment clause of the contract and maintain management rights. So the union position would be that work assignment clause was a gain in a prior negotiation. However, when it comes to interest, reduce overtime cost for management, but for the unions, keep employees from being disciplined for failing to perform in temporary assignments. Some of the steps that are involved in interest-based bargaining include identifying the issues, identifying each party's interest on those issues, developing options, evaluating options on various standards. Are they feasible? Are they beneficial? Are they acceptable to both sides? And finally, reaching a consensus solution. The advantages of interest-based bargaining includes better communication, uncovering additional ideas and superior solutions to problems, uncovering new options, and also explaining the critical why behind each party's interest or proposal. The disadvantages of interest-based bargaining include the fact that it is time-consuming. Negotiators may have difficulty transferring a proposed creative option into a practical, concrete solution. The standards suggested by the interest-based bargaining negotiators are often not precise and can be subjective, therefore not easily agreed to by both sides. The categorization method of integrative negotiation method includes exchanging information, developing a common list of issues, agreeing on compatible issues, exchanging equal value issues, resolving remaining issues using distributive bargaining. The 5 steps of the categorization method of integrative or win-win bargaining is exchange information and identify all of the issues to be negotiated. So each side explains its interest and concerns on the issues. Number 2, you develop a list of common issues to you and to the other side that were discussed by either side during the first step and seek to classify each issue as one compatible. In other words, similar interest to exchange. And third, distributive. Those issues that are not compatible between the two sides, in other words, they cannot be traded, and therefore whose value must be distributed, hopefully in a win-win process between both sides. Step 3 is reaching final agreement on each of the compatible issues and removing them from any further negotiations. Step 4 is trading or exchanging issues of approximately equal value. So in some cases, several issues can be included in a single exchange. And step 5 is resolution of any remaining issues, which often is accomplished through the distributive bargaining on each separate issue. So then comes the point of crisis or reaching an agreement. So here's where negotiators reach a decision point. If agreement cannot be reached, this may be the point of crisis. And finally, if you have reached an agreement, you have the closing stage. Knowing that an agreement has been reached, the people involved become psychologically committed to the agreement. And try to learn from the mistakes of others. In these tips from experts, you can see several different mistakes which should be avoided during any negotiation process, whether you're working for the union or labor side or whether you're working for management. So let's look at a couple of these. So on the union side, number one, make certain that when an employer claims it is unable to meet your wage demands, you demand information on the financial condition of the company. Under the National Labor Relations Act, you're entitled to financial information if the employer claims a lack of funds. This is the inability to stay competitive or the loss of necessary profit margin. So if they say we cannot do this, you can ask for information why. So if they share that information why, that means you'll probably understand their side because you don't want the company to go bankrupt. Because if the company goes bankrupt, that means all employees, member or non-member, will lose their jobs. Number two, for the union side, remember that if negotiations reach an impasse, and such an impasse is not the result of an employer's bad faith negotiations, an employer may unilaterally implement its last offer. Such an action allows the employer to bypass the bargaining unit's representatives and deal directly with the employees, thereby undercutting your ability to represent your members. On the management side, let's look at one of them. Unless you want to provide the union with all the company's financial information, you should make certain that you do not claim a financial inability to meet the union's wage demands. The courts have ruled that if management rejects a union's proposal on grounds of inability to pay, the employer's financial condition then becomes relevant to the negotiations, and the employer must provide the union with financial statements which can include profit and loss statements, your assets, and your liabilities. So to avoid this problem, management can simply state, we are not willing to agree with the union's wage demands. Such unwillingness may be based on a number of factors and does not require management to reveal financial information to the labor or to the union side. Number two, make it clear at the beginning of the negotiations what authority you do or do not have to reach a binding agreement on behalf of the employer. If you need to check with the higher authorities before making a commitment, make sure you have explained that to the union's negotiators. Otherwise, springing the need to go back to management can be seen as a delay tactic that may be deemed an unfair labor practice. So again, learn from the experts' advice and suggestions, and obviously try to avoid some of the mistakes and take advantage of the solutions that have worked in the past. Good luck.